Thank you. This hearing is in the matter of case number CFI 034-2021 before Justice Lord Angus Glennie. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by ARAA Group Advocates and Legal Consultants. Lead counsel is Mrs. Asha Bijoy. The defendant is represented by Emirates Legal FCE. Lead counsel is Mr. Saeed Hussain.
Yes, thank you. Ms.
Thank you.
Bijoy, I think you're the claimant, is that right?
That's right, my lord.
Right. There's a number of matters being raised in a list of agreed list of items to be discussed. Do you want to deal with those first, or should I? The main one, I think, is the complaint by the defendant about documents that you lodged on the 15th of March. Is that right?
That's right, my lord.
Should I hear from the defendant first about these, or do you want to explain your position?
I would leave it up to my lord's discretion, my lord.
Well, perhaps you could explain first what has happened and why these documents have been lodged in the way they have been lodged quite a long time, very long time after the time for producing documents. And then,
Yes.
then I'll hear Mr. Hussain as to what he says about it.
Thank you. Much obliged, my lord. Regarding these additional documents that were filed on the 14th of March, these documents were documents that has assumed importance when the defendant filed their additional witness statement on the 7th of March. So on 7th of March, as per the CMC order, both parties had a deadline to file additional witness statement on the 7th of March. And on 7th of March, the defendant has filed an additional witness statement, bringing in a lot of additional issues or contentious point, whereby it becomes necessary for the claimant to then do a detailed research and study of the documentation. And that's how they have come across these documents, which are relevant and material to the outcome of the case. Although we do understand that, of course, while filing the documents, additional documents, the claimant indeed marked a copy to the defendant. And the reason why these documents are coming in late, it's because earlier these documents were not available with the claimant, or they could not retrieve these documents. And these documents assumed importance by the filing of this additional witness statement on the 7th of March.
But when you say they couldn't retrieve them, what was the problem?
These documents did not come to them initially when they did the research. This is what my instructing counsel has informed me, that although they have been repeatedly following with the client for instructions and documentation, these documents had not come to them. And this had come in at it's only subsequently when this witness statement has come in that the respective person at the claimant's office did a detailed research, and that's how they have come across these additional documentation.
So it wasn't a problem with technology or anything. It was simply that they hadn't looked in the right places.
There are also certain changes in the management, my lord. One of the key officers from the claimant has left office. So that, I believe, has caused to some extent the delay in retrieving these documentation. And moreover, it is the specific issues that have been brought into in the additional witness statement that has really kept the claimant to go and do a detailed analysis, because without these additional witness statement, these additional documentation would not have assumed importance. But now we are in a stage where, because of this additional witness statement and the contentions that are taken in the witness statement, these documentation must come on record, because these are extremely relevant and material to the outcome of the case.
Tell me what are the new points you say have been raised in the defendant's witness statement?
Of course, my lord. If I may take you through the My lord, one aspect that has been brought in the additional witness statement is regarding claimant's nomination.
Stop a second. Where do I find the witness statement? Is this the reply witness statement of 7th of March?
That's
Is that
right,
right?
my lord. Yes, the reply witness statement.
Let me just open it. Right.
If your lordship may look into paragraph 12 of the reply witness statement, your lordship will see that.
Hold on a sec. Right, paragraph 12, you say?
That's right, my lord. In paragraph 12, defendant has taken a specific position that the claimant was making a false statement about its services as unique services. The defendant also in that same paragraph says that the claimant was making false statement regarding their reputation in the market. It is in this respect that we would like to file the additional document exhibit number 40, which shows that the claimant was indeed nominated in as an Intersect Award nominated, and which shows that, of course, they were providing unique services and the claimant, the defendant knew about it even prior to they approaching the claimant. Similarly,
Right.
in paragraph 13.1, 13.2, and 13.3 and 13.4, in the reply witness statement, the defendant did not states that the defendant did not attempt for any collaboration. The defendant also pleads that without having any knowledge in the marketing and selling of services provided by the claimant, the defendant could not promise or commit to achieve any targets. And this is a very important point, my lord, because there has been discussions right from the beginning on the targets, on the 30 million targets that has been mutually agreed by the parties, starting from the MOU till the definitive agreements that are signed by the parties. And in the reply witness statement, again, the defendant takes the position that they did not approach the claimant and they did not have any understanding about the marketing and the selling of the products, and especially on the target. And it is in this respect that the claimants would like to file an additional document, that is exhibit number 41 and 42, which clearly confirms that the defendant is very keen on partnering with the claimant. And in fact, the proposal to achieve the 30 million target has come from the defendant and not from the claimant. And it's an extremely important document that goes to the very root of the case, my lord. And it is only in the reply witness statement that the defendant has time and again taken the same position, adamantly that it is not the original position that they have taken in the claim. Although there has been communication back and forth between the parties, reply witness statement, again, they take the position that it is not the claimant, it was not the defendant, it was the claimant who approached them. And there was no agreed 30 million target.
Right.
Similarly, in paragraph number 14.2, 19.2 and 20.1, the defendant states that they could not have engaged in the process of selling the products offered by the defendant. The defendant also states that they never suggested the target. In this respect, also the claimants, when they went back and did further research, they managed to retrieve some documents, especially on the sales targets, and also a lot of communications, email communications back and forth between the parties that shows that they were indeed involved in the marketing, and also they had knowledge about the products that the claimants were providing. So basically our point is that, my lord, these documents are relevant and material to the outcome of the case. And it is humbly requested that these documents be taken on record and the claimant be allowed to keep these documents on record. In this respect, also, my lord, I would like to draw your kind attention to the RDC provisions, especially RDC 28.59.
Yeah, hold on. 28.59.
If I may read the RDC provision, it says.
Wait a second. Wait a second. Yep.
Apologize, my lord.
Yep.
28.59 reads, within the time ordered by the court, the parties may produce to the other parties any additional documents which they believe have become relevant and material as a consequence of issues raised in the statement of case, documents, witness statement, or expert report submitted or produced by another party or in other submissions of the parties. My lord, I do note that the beginning of the section reads within the time ordered by the court. And that is why the only court order that we have in relation to the production of documents is the CMC order. And the CMC order, if I may.
Hold on. Yeah.
And in the CMC order, regarding the witness statements in paragraph 9, it only talks about reply witness statement. It does not leave any room for the parties to file any additional documents if any necessity were to arise after the parties have filed the reply witness statement. So there.
Did you ask for any such order?
No, my lord, we did not ask. Let me please clarify or beg to this court that the reason why we did not make a specific application is because the only option for the claimant to take a specific order in this regard is by filing an application under Part 23. As my lord may note, the Part 23 application is going to cost additional expenses for the claimant. And the claim amount in this case is hardly less than 1 million. If we were to make an additional application under Part 23, then definitely the defendants will be filing a defense. The court will have to spend its valuable time in hearing the application. All of it is going to cost additional time and expenses for the claimant, especially for a small value claim like this. And also in this regard, we would like to draw the court's client attention to the fact that the trial is 1 month away, and we still have several opportunities before which the parties can raise an objection to these additional documentation. In fact, there is a specific provision under RDC, provision number 30.
30.
Yeah, 35.30, my lord.
Sorry, 35.
Sorry, I stand corrected, 35.30.
Yeah.
Which reads, the court will expect parties normally to agree that the documents are at any rate, the great majority of them.
Hold on, I haven't got that. Rule 35.
Yes, my lord, 35.30.
I don't have that in my book.
Would it help if I read that loud, my lord?
Is it? That's in Part 35.
Yes, my lord.
Miscellaneous provisions relating to hearings.
Yeah, Part 35 is about trial.
Yeah, sorry, my fault. Yes, I have it, yeah.
35.30 reads, the court will expect parties normally to agree that the documents, or at any rate, the great majority of them, may be treated as evidence of fact stated in them. A party not willing so to agree should then, when the trial bundles are lodged, write a letter to the court with a copy to all other parties stating that it is not willing so to agree and explaining why that is so. So, my lord, my point is, in this matter, the trial is 1.5 months away. And if the defendants would like to raise an objection to these additional documentation, they always have an opportunity to do that by writing a letter to the court.
They have raised an objection.
Yes, my lord, they have raised an objection. So their objection is that they are not raising an objection as to the relevance and materiality of the documents. Their only objection is that the document is filed outside the procedural timetable. And also,
You haven't asked for an extension.
Yes, my lord. We do acknowledge that these documents were filed outside the procedural timetable. But the only reason is because there was no, the CMC order is absolutely silent about an opportunity for a party to file additional documentation if they require to.
You can't complain about the CMC order being silent if you didn't ask for any provision. The fact is, you should have applied to the court for permission to lodge these documents late, and you didn't. You say you didn't because it would cost too much.
Yes, my lord.
That's not a good excuse.
Yeah, yes, my lord. But it is our humble request that if the court could kindly accept these documents, we are willing to rectify the procedural timetable. If it would help the court, we can request the claimant to file an additional affidavit, and without derailing the procedural timetable, we could submit these additional documentation with an affidavit or an additional witness statement.
Yes, I see. Okay, let me hear what Mr. Hussain has to say then. Mr. Hussain.
Your Lordship, I have only 2 points now left to argue since most of the points have been brought before the court. First is that it is now established beyond reasonable doubt, based on the admission made by the counsel for the claimant, that they did not comply with the CMC order, and they agree and confirm that the documents were filed outside the timetable prescribed by the court. Now, if we look at the objections which they have filed, which are also on record, rather their response to our objections, they say very clearly that this procedural scheme in the RDC does not apply in the instant case, which I would like to demonstrate to the court is clearly not correct. If I may have the permission of this court, may I refer to RDC 28.15, which refers to the standard production of documents. Whenever we talk of the standard production of documents, we would always refer to 28.15, and 28.15 very clearly states that standard production of documents within the time ordered by the court. So each party must produce all documents available to it on which it relies, including public documents and those in public domain. I don't want to go through this provision. I just want to identify the provision, which, because the order in the CMC refers to the standard production of documents, and this is covered under 28.15. Now, Your Honor, the manner in which an exhibit can be filed. Now, if you look into the provisions of the RDC, I would like to draw the attention of this honorable court to RDC 29.85. If your lordship has this particular provision, 29.85.
29.85. Right.
Your Honor, 29.85 talks about exhibits. It says, manner of exhibiting documents. A document used in conjunction with an affidavit should be produced and verified by the deponent and remain separate from the affidavit, identified by a declaration of the person. And then it says the declaration should be headed with the name of the proceeding in the same way as the affidavit. This is 29.86.
Yeah.
And 29.87 says first part of each exhibit should be marked. So I don't want to go into the details of this, but the point that I want to bring across is if you read 29.85 and if you look at 29.83, which is right just there, it says that if the court directs that an affidavit is to be filed, and then 29.85 explains how if a document is filed in support of an affidavit. Now, Your Honor, I want to take you to what happens when the exhibits are filed in conjunction with a witness statement. Here we have a witness statement which was filed, and these are documents which I believe, or I understand them to have been filed in conjunction with a witness statement. And may I then draw the attention of this honorable court to 29.
Hold on. These documents, you're talking about exhibits 39 to 44. Which witness statement are they in
They
conjunction
haven't referred to any witness statement. The point that I was trying to, why I wanted to read 29.26 is, I wanted to draw the attention of the court that what happens when the documents can be filed, exhibits can be filed either in support of an affidavit. And that is where the court orders the party to file an affidavit, or the party may, in support of its witness statement, identify and say, I rely on this, because in a witness statement, a party must identify the information that it has relied upon to come to the evidence that it is providing to the court, or in terms of the statement that it is deposing before the court. Now, none of these exhibits, Your Lordship, refer to any permission granted by the court, which is established, but they also don't refer to any particular statement made in their witness statement, nor the relevance of that witness statement, relevance of that statement contained in that witness statement. So therefore, it is unclear how can few documents, a bundle of documents, be brought before the court of law without seeking the consent of the other party. Now, there could have been a possibility, Your Lordship. The other party could have possibly approached us, had a discussion with us, and asked for a consent order, and showed us the relevance of the documents and why this could be considered. So we could have then applied our mind, looked into if this was, from our perspective, a document that we would like the court to look into as well and relevant from the perspective of the court. That was not done, Your Lordship. Now, if you are trying, as the counsel said, we're trying to save the costs. One of the best way to save the costs is to approach the counsel for the other party, which didn't happen in the instant proceedings. The second procedure was to file a Part 23 application and seek an order from the court, which was also not done. So clearly, Your Honor, my counsel, the opposite counsel refers to RDC 35.30, which he read before the court. Now, Your Lordship, 35.30 refers to trial bundles. I will refer to 35.30 when I'm preparing trial bundles before the hearing. And when I'm preparing a trial bundle before the hearing, I'm going to look into the documents which both parties should agree, which are the documents, how we're going to place them, how we agree to what is being submitted in the trial bundle. So that does not pertain to the submission of documents, the standard production of documents. It's a completely different matter and cannot be taken into account. Another important point, which my learned counsel made, was she stated that the documents were not available then. So, and then she also stated that these that we had someone who was not available in our office who could have provided us these emails. Of course, Your Lordship, they filed a statement of claim, and if you look into these documents which they have submitted, and if you will note that they are documents from 2018. So it's not that there were some documents which were there from 2000 to from a very from for a long time, and it's concerning because the procedure prescribed by RDC was not followed. The scope of the CMC order was not adhered to. Clearly, these documents cannot be taken on record, and the relevance of what they filed was only raised by them in their respective email only after we objected to the same. And even if before you, two paragraphs were provided, paragraph 12 and paragraph 19. In paragraph of the witness statement, of the additional witness, second witness statement.
Yep. Yep.
And the counsel read out to you some of the clauses, and she said that we have stated, we have never denied the fact that we sent an introductory email to the parties. It's a practice in United Arab Emirates that sometimes either parties approach us or we send introductory emails to parties introducing ourselves, an introductory email to a party introducing ourselves, that this is what we have to offer. And then it was for them to engage with us or not. As a matter of fact, they chose to engage with us. And then there were discussions in this case. But if you look at this case in its entirety, Your Lordship, the only point that arises for discussion in the instant case is just one issue. And that issue is, if there was an obligation on the defendant, which is us, to guarantee an amount of AED 30 million during the first year of its operation. And if this was the guarantee given by us, where was it given? Where was it stated? Is it contained in the definitive agreements that we executed after the memorandum of association was executed by us? And if they cannot even identify even a single provision in any of the different definitive documents where this obligation has been stated, then clearly this could not be considered as a claim based on merits. And second important point is, why are you relying on extrinsic evidence such as emails when the definitive documents have been executed in this regard, and when the definitive document clearly states that this is the understanding between the parties, and this overrides any other discussions that parties had in the past? Now, Your Lordship, if this is the central issue and theme of this case, and if this is the principal issue that governs this case, then all other requests for either for production of documents or for looking into the relevance of the evidence sought must be weighed and considered in light of these fundamental aspects. I don't want to argue further on this issue, Your Lordship, but I wanted to bring to the attention of the Honourable Court these points.
And I understand what you say about the critical main issues. I have a problem at the moment. First of all, I haven't heard the full argument and the evidence and so on. Secondly, I have a list of issues which runs to 29 separate issues. And at this stage, the court isn't in a position to decide whether you're right on that or not. You may well be. Therefore, I can't make a decision on documents on the assumption you're right, because it'll be contested. What I just want to understand is this. I fully understand the point that the way these documents have been introduced is not consistent with the rules of the DFC. So you needn't persuade me on that. But are you saying that the documents are irrelevant, or you don't know if they're relevant?
Your Lordship, on the first reading of the same, we do not see how they are new documents. We do not see how they are relevant to the entire proceeding. We do not see how they are relevant to the claim or to the issues which they have requested for the issues to be framed before the court. So they are not relevant at all. And we have not been given an opportunity to look into the relevance of these documents. We have not made a formal submission in this regard.
One thing that occurs to me is a way of resolving this, because we have the trial coming up in 6 weeks, 5 weeks, 6 weeks maybe. And this has to be resolved fairly quickly. Otherwise, parties don't know where they stand. One solution would be to deal with the regularity point first and require the claimant within 7 days or even within 5 days to file an affidavit exhibiting the same documents or referring to those documents and explaining, first of all, why they come in at this late stage, and secondly, what the relevance is, as they see it, to the issues in the case. At that stage, if that is done by close of business on Friday, for example, that would give you, say, 7 days to to file any application you want to exclude these documents on grounds of relevancy. Does that make sense?
Yes, Your Lordship.
Ms. Pajoy, does that make sense to you?
Yes, my lord.
I think that is the best way of dealing with it. And that enables both parties to have their say and then bring it back before the court if necessary. I hope it won't be necessary, because with any luck, parties can. And Ms. Pajoy, I would reiterate what Mr. Hussain says about the need to talk to the other side if there's any issue.
Court can
To discuss it with the other side first.
Yes, my lord. We would ensure that we will file an affidavit within 3 working days.
Well, the 3 working days, that's Thursday. That's okay. By let's say let's fix a time for it by midday on Thursday.
Yes, my lord. We can do that.
So I'll make an order that by midday on Thursday, the will file and serve an affidavit. I don't think you need physically attach the same documents, but referring to each of exhibits 39 to 44 of the well, what are they exactly? Referring to each of their exhibits 39 to 44, explaining why they've only just been introduced into the process, and explaining also what is perceived to be the relevance of these documents to the issues in the case. Now, if that's done by midday on Thursday, how long would you like Mr. Hussain to respond, if you want to respond, on the question of irrelevance and therefore should be excluded? I should say this, that if there's an argument about whether they're relevant, the best thing is to deal with that at trial. But if some issues, some documents are clearly not relevant to any issue, then of course it'll be open to you to make an application to exclude them. So how long would you like to consider?
Your Lordship, I would like to seek a time period of 7 days. I will try to do it earlier, but 7 days would help me because I also need to seek instructions from my client.
Okay.
So 7 days.
Within 7 days thereafter.
7 days thereafter.
Within 7 days thereafter, the defendant, if so advised, should make any application to the court concerning the relevance or admissibility of these documents. That covers it, I think, doesn't it?
Your Lordship, can I just raise one issue, which is not an issue though, but just for seeking guidance from the court. Your Lordship, I'm aware that under 29.83 of the rules of the court, the court can direct an affidavit to be filed in the proceedings.
Yes.
But in the instant case, Your Lordship, they have not, ideally they should have moved an application. So they are getting the benefit of not moving an application, seeking an order from the court.
Yeah.
And then if we have to move an application, requesting the court, seeking an order from the court to exclude the documents that have been filed, we need to move an application and incur an expense. So I'm not saying that we would not do that, but I was thinking.
I follow your point. Mr. Bajoy, there's some force in that point, isn't there? So why do we say that within 7 days you must notify, the defendant must notify the claimants of their objection, if they have any, to the documents being filed. And on receipt of any such letter, the claimant must must make such application as is necessary for these documents to be admitted. Does that cover your point, Mr. Hussain? It puts the onus and the expense of the application on the claimants.
Yes, Your Lordship.
You can't object to that, Ms. Bajoy, can you?
Yeah, yes, my lord. We are absolutely fine with this approach.
Okay. Right. So I hope, Sharma, are you there?
Yes, Your Honor.
Did you get a note of that sufficient to help you draw up the order?
Yes, Your Honor.
Thank you very much. Well, does that then deal with the point about the documents?
Yes.
Very well. Thank you very much for that. The other points I think are less controversial. The time for the trial down
Now,
for 5 days.
the second point is a trial, 5 days for a trial. Your Lordship, I feel that to be very fair and honest, looking at the issue involved, it should not take us more than 2 days, a maximum. And in the worst case scenario, we can reserve the third day as well.
Ms. Bajoy, I think you said 3 days, but you both agreed it's not 5 days. Well, should we say 3 days?
Yes, we are also agreeable to this approach, my lord, of keeping 2 days and the third day as an optional, if the requirement be.
Is there any practical advantage of that, or is it a matter of expense that you have to pay depending on the length of the trial?
No, my lord. It's basically because just in case if we're not able to complete the trial in 2 days, just to ensure that we conclude we have enough time. That is the reason why we thought.
Is there any reason not to say 3 days?
We are fine with, definitely we can agree on 3 days, my lord.
Mr. Hussain, is there any reason not to say 3 days?
I have no objection at all, Your Lordship.
If finish in 2, you will both be rewarded for your efforts. Thank you. So we'll change the estimate to 3 days. Now then there's a pre-trial review and checklist. What is the normal timetable for this?
As per the RPC, my lord, pre-trial timetable is due 4 weeks before the trial. Ideally, today is the day on which the pre-trial checklist is due for filing. But since we are having a progress monitoring today, we thought of discussing the pre-trial checklist also, so that we can submit the pre-trial checklist based on the discussion that we have today on the pre-trial aspects.
Okay.
This is only a submission from our side. If it is acceptable to Mr. Hussain, I guess we can then have a quick discussion on the pre-trial checklist.
Does that sound sensible, Mr. Hussain?
Your Lordship, I was only thinking from a practical perspective. If we could increase the time, the trial by 6 days or 7 days, that was a point that I had in mind, considering that we are going to spend some time on responses to these issues, seeking instructions from the clients, finalizing. Maybe there are any applications that we need to file ahead of the trial and all those things. So in this regard, if the trial date could be changed first, I was thinking from that perspective, then automatically this particular date will also be changed.
Right. So you're suggesting putting the trial off for a week, effectively?
Effectively.
Give me 1 second. That puts me in difficulty.
I have just been informed by my team member that is a week after that will be Eid, and that is a big holiday here. So that means effectively 5 days holiday.
Yes, and also I am away for half of that week, and then I am away for two to 3 weeks after that. One possibility would be simply to start the trial instead of on the 25th, the 25th of May. Started on the 27th. But does that achieve much? Maybe it's not long enough.
27th?
My lord, allow me to step in. The trial as of now stands on the 25th of April.
Yeah, for 5 days.
Yeah, I think if it would help, we are okay to have the trial started on the 27th. Then following the 3 days, 27th, 28th, and 29th would be a Friday.
Would that suit you, Mr. Hussain?
It was May, right? We are referring to April, so that's
April.
Yeah, it's
a month from now.
Yes. So I feel Your Lordship, because we have witnesses involved here as well, and this is the month of Ramadan that is also there. So there are many. So I was wondering if it could be possible in the in the month of May, after Eid, whenever Your Lordship has an opportunity in the month of May. That would be highly appreciated.
Yes, I have no availability in May. You say Eid is the week of the 2nd of May, is it?
That's right, Your Lordship.
And then I'm away till the 25th, 26th. And then I have a trial on the week of the 30th. Then I'm not available. It would have to go into July. I wonder if I'm reluctant to put it off that far, because I'm not in control of the court diary. That's for the registry. But what about? I mean, the problem you're talking about, the reason for suggesting it today, is because of the ongoing discussion about the documents. But in a sense, when that is resolved, that will have assisted with preparation of the case, because you will then have discussed the documents in the context of the existing issues. And I wonder whether in those circumstances we actually need to postpone the trial by more than a day or two. I'm quite willing, within the period of presently fixed for the trial, to start on the Wednesday, the 27th, rather than the Monday, if that helps. But if it went beyond that, it would be a delay of 2-3 months.
In which case, Your Lordship, we will take the first available date, which is 27th.
If you're happy with that, Ms. Bajoy, are you happy with that? Take the 27th.
27th is fine with us, my lord.
That's right. We will then alter the trial dates. Let's adjourn the trial till the 27th of April. And the 3-day trial from the 27th, 28th, and 29th of April.
My lord, one concern that I would like to highlight to this court, that as Mr. Hussain was mentioning, it is the month of fasting.
Yes.
So I am not sure whether the witnesses would be available towards the evening hours, and I do understand that the trial starts by midday. Right. So we might have to prepare for 3 or 4 days so that to accommodate the limited timing available on a daily basis.
Well, I'll tell you what. I think this is the best thing for you and Mr. Hussain to talk about this and discuss with witnesses, because of the fasting, which I understand. And rather than make an order at this stage postponing the trial, leave it to start on the 25th, but parties can agree, once they've discussed it with their witnesses, agree to start later than the 25th if that is considered in the best interest of proceeding. Are you happy with that, Mr. Hussain? I think it's probably safer that you discuss it with your clients and with Ms. Bajoy. And if you want to postpone it, then make a joint application to the registry, and we'll note in the order from today that may happen.
Right, Your Lordship.
Thank you.
Your Lordship, if I may ask, the hearing will be through the video conference as we are doing it now, or will it be in person in Dubai?
No, it'll be the video conference.
Right.
Now, the normal times, I'm in the UK, so it is now 9:45 in the UK. It's 12:45 with you?
Yes.
That is correct.
I'm happy to start at 9 o'clock UK time or 12 o'clock Dubai time. Or I could, if it helped with Ramadan, I could start at 8 o'clock UK time. It would be 11 o'clock.
That would be perfect. That would be perfect. So that if the witnesses need to go for prayer at 12:30 in Dubai time, they can take a short break. So we would have covered substantially some of the issues.
Yeah. So let's fix, at the moment then, let us fix the trial to remain subject to discussion, to remain in that week of the 25th, starting on the 25th, unless by agreement it starts later. And to the hours sitting from 8 o'clock UK time, 11 o'clock Gulf time. And what I would suggest is that the break for prayer is 12:30.
Around it will vary from the month to month. So I presume it will be around between 12:30, 12:35, 12:36, around approximately.
So that gives an hour and a half before breaking for prayer, which is quite convenient.
That's right.
And we'll sit on till perhaps sometime between 2 and 3 in the afternoon, come to a halt. Is that about right?
Your Lordship, we can even do it easily until 4:30 in the afternoon.
I think too long a day gets everyone loses the ability to concentrate. Let's aim maybe aim to finish around about 3 in the afternoon, which is. No, hang on. No, sorry, you're quite right, Mr. Hussain. I was getting the time difference mixed up.
So 4:30 Dubai time would be.
Yeah. We could continue until about 4:30 Dubai time. And we can run on for a bit if we're just finishing a witness, or stop a bit earlier if we just finished a witness. Whatever's convenient for the witnesses. Will any interpreters be necessary?
Required for the claimant.
Not from our side here.
Yeah, thank you. Right. Are you happy to deal with the other matters on the checklist now, or do you want to deal with those informally once we've finished the discussion about the documents?
Yeah.
I would just raise one point, Your Honor, with regard to one issue, if that would be helpful for the court and for the counsel for the claimant. We have 29 issues somehow, and I feel that these 29 issues could best be consolidated into 3. And then what we could possibly do is say, if we could draft issues in such a manner that 3 main and critical issues, and then these sub-issues, and we can then make a reference, since they are on record, and we can say if issue number 1 is addressed, issue number 7, 8, 9, 11 is addressed automatically. Issue 2 is addressed, so issue number 2, 11, 14. And so this was the method I thought would best help the court to understand the critical issue involved in the instant proceedings.
I think there's some force in that. Ms. Bajoy, are you happy with that?
Yes, my lord.
Do you think you'll be able to reach agreement on limiting main issues?
If we could have a quick discussion in the court now, so that that we are not getting time wasted back and forth exchange of communication. We are pretty flexible in terms of the issues.
Right.
So we have also identified 3 or 4 issues. However, Mr. Hussain, if you have already prepared for the issues, we
what
can.
I was, Ms. Aisha, what I was thinking is, if possible, to save the time of the court, if we could make a simultaneous, both of us agree on a list of common issues, and if we have a disagreement, then we can send the list of issues framed by you and list of issues framed by us to the court, if your lordship permits us. And then the court can consider what it deems fit and necessary. And if the court wants to call for a short, quick meeting, we will assemble immediately at court's convenience, should that be necessary.
I think the best thing is let's not stop this hearing now and discussion. Why don't you exchange suggestions after the hearing today and try and agree on something. If you can't agree on something, then each of you can lodge in process a filing court your own version of the list of issues, and we needn't then reach agreement. I can use both of them to get a flavour in my own mind as to what the main issues are as you both see them. It can sometimes take a long time to agree a simple document because inevitably each party wants to put their own gloss on it. So try and agree something, file it in court, but failing that, each file your own within 2 weeks of today.
Yes, my lord. The suggested approach is fully acceptable to the claimant, and we will do that.
Very well. What else needs to be discussed?
Now there's only the pre-trial checklist.
So what is, take me through, Mr. Joy, take me through the pre-trial checklist, and we can hear each party as we go through it.
Yes, my lord. The pre-trial checklist in the initial part talks about the name of the legal representative. I do not think all of that is relevant for the current discussion. I think the more important part when it comes to the pre-trial checklist is regarding the cost. So we need to have an agreement on when the parties will be filing the cost sheet. I guess we can agree on a time on which both parties can file the pre-trial checklist, and the court can then decide or take the pre-trial checklist on paper. Along with the pre-trial checklist, we would also submit the cost sheet, estimated cost for the trial, and the cost incurred till now.
Yep. Happy with that, Mr. Hussain?
Your Lordship, I mean, cost thing was all filed one day before the hearing, so that we will file one day before the hearing.
Yeah. Okay.
Another aspect to be considered in the case, the pre-trial checklist is regarding the filing of the bundles.
Yeah.
As per the CMC order, the deadline for filing the trial bundle is on the 3rd of April.
Yeah.
And the parties have already had a discussion and has agreed on a process whereby the claimant's counsel will come up with an index and the list of documents, will send out the list to the defendant's counsel by the 30th of March.
Well, how can we do that if we're still in discussion about the exhibits 39 and 44?
Yes, my lord. So I guess we would then have to agree on a timeline for filing the trial bundle, which would be after the day given to the defendants for filing their objection, if any, to the additional documents.
So if we, what day is the trial?
Trial is on the 25th to 27th. So we could agree on filing.
Yeah, Karen.
I was thinking it is my humble submission that we agree on 10th of April for filing the trial bundle.
Is that after the 3 days and the 7 days?
Yes, my lord.
10th of April, Mr. Hussain, for filing the trial.
10th is a Sunday.
10th is a Sunday.
Right, why do we make it 12? What about 12th?
Let's make it 12th so that
12th.
we can exchange.
Yeah, 12th is, so 11th we can exchange, so 12th would be appreciated.
Very well. We'll aim for 12th. If there's a problem about the disputed documents, then parties can agree to extend the date for trial bundles. Okay?
Yeah. Also, my lord, regarding the full completed trial bundle, as per the RDC, the trial bundle need to be uploaded 4 days for the claimant and 3 days prior to the trial for the defendant. although we endeavor to submit the trial bundle by 12th of April, can we have an opportunity to add on to the trial bundle to include the skeleton argument, the reading list, and all the additional documentation? And we both agree on a firm timeline of, let's say, by 19th of April for the claimant to finish all submissions from its part, and maybe on the 21st of April for the defendant to complete the trial bundle.
By things like skeleton arguments and so on.
Yes, my lord.
That sound right, Mr. Hussain? Or are they Sundays?
Can I just seek permission 1 second from the Honorable Court to speak to my colleagues?
So, she's talking the bundle.
So the skeleton dates, if this court may permit me to address Ms. Bajoy, are you referring to the skeleton dates also changing to 19th and 21st? Because initially you were supposed to file your skeleton on 13th, and we were supposed to file our skeleton on 14th. So is this what you're proposing? That
Yes,
change it?
it's because as per the RDC, the skeleton need to be submitted by the claimant only 4 days before the trial. Similarly, for the defendant, it is only 3 days before the trial. But in the CMC order, we had agreed on a date which is much earlier than the day scheduled for the trial. And also, in the original CMC, I guess the trial was supposed to start on the 20th of April. But now the trial is pushed to 25th or 27th, possibly. So in which case, it would only help the parties if they have more time to prepare and work on the skeleton argument and the documentation, because there is enough room within the RDC to file trial bundle or the completed trial bundle and the skeleton argument at a later time. So it is only a suggestion.
In which case I have no objection, Your Lordship.
Very well. We'll make that part of the order. Ms. Bajoy, can I assume that you are making a note of these various points that you can liaise with with the registry, just to make sure that we have all the details down?
Yes, my lord, I will write an email.
And of course, you'll include Mr. Hussain in any emails.
Definitely, my lord, I will definitely do that. Thank you.
What else needs to be discussed?
1924 bundle.
I think as far as the claimants are concerned, we have pretty much covered all the points that we had to discuss in the progress monitoring.
Very well, thank you. Mr. Hussain, are there any points that you wanted to discuss?
Your Lordship, I think everything is covered as of the moment.
Very well. Well, thank you very much. It's been a useful hearing, I think, and I hope that with any luck we will be able to make progress now with a view to starting either on the 25th or the 27th of April. And but can you emphasize again, can you liaise with the registry about the order as it is to be issued?
Yes, my lord, we will do that.
Thank you very much then, and this concludes the hearing.
Much
Thank
obliged.
you, Lordship.
Thank you.
Thank you.